Yes, greetings to everyone. It's a great pleasure to welcome you all to the third seminar of Climate Change and Law Seminar Series organized by the CCLLAB of KHAS University School of Law. We are particularly delighted to host Mr. Cameron Diver today, who is the Deputy Director General of the Pacific Community, which is the Pacific region's oldest and largest intergovernmental organization. He's going to deliver his lecture on the law in the service of climate justice, perspectives from the Pacific on one of the defining global issues of the century. Climate justice are two words we hear more and more, and we are looking forward to hearing from Mr. Diver to understand what is really meant by this concept and how law can serve in achieving the climate justice with a view of Pacific region and the challenges that region is struggling. Before starting, I would like to introduce Mr. Cameron Diver to our audience. Mr. Diver graduated with bachelor's degrees in law and arts from the University of Auckland in New Zealand. He completed a Master of Public Law and also a Master in International Relations from the University of New Caledonia. Previously, Mr. Diver was the head of External Relations and Regional Cooperation for the Government of New Caledonia, Chief of Staff to the Minister of Budget, Finance, Taxation, Energy, the Digital Economy, Audiovisual Communication, Tertiary Education and Research. He was the Director of the Department of Education of New Caledonia, Deputy Director of Legal Affairs and General Administration, and also legal counsel to the government of New Caledonia. Mr. Diver has also worked in private legal practice as a barrister and international arbitration assistant to Sir David Williams QC at Bankside Chambers in Auckland, New Zealand. In addition, he was law clerk to the Chief Justice of Cook Islands and at the courts of Dubai International Finance Center. He has lectured in constitutional law, administrative litigation, climate change litigation, and international environmental law, and been a keynote speaker at numerous international events. He regularly publishes articles on the law, together with issues in international relations and sustainable development. Mr. Diver has acted as the official representative of governments and organizations to states and international organizations, and in this capacity, he has led delegations at multiple negotiations, conferences, and meetings on a bilateral level and in multilateral forums. In particular, Mr. Diver led Pacific Communities delegation at 74th session of the United Nations General Assembly, the UN Secretary General's Climate Action Summit, and UNFCCC's COPs 24 and 25. Mr. Diver, the floor is yours now.
Thank you very much for that very kind introduction. And first of all, let me commence by thanking you very much, Asluhan, for this very, very kind invitation. I'd like to thank also the KHAS University and the Climate Change and Law Laboratory. Add my thanks to Professor Baysal, the Dean of the faculty, and of course to Iucn for her support in helping set this up. And if you'll allow me, to Dr. Virginie Tassin-Campanella for her very kind introduction that allowed us to make contact on this fascinating subject. Greetings to you all, merhaba, and it's wonderful to be with you. If you'll allow me, I'll just go ahead and share my screen and we can begin. I hope that has come up. So today it's my great pleasure to discuss with you issues around law in the service of climate justice and to provide some perspectives from the Pacific region on what is, not only in my opinion, but in the opinion of many, one of the defining global issues of our century. To begin, I'd like to provide some context around what the organization that I currently serve, the Pacific Community, is and does. the Pacific Community that goes by the acronym SPC, because when it was created in 1947, it was known as the South Pacific Commission. And it was established as an intergovernmental organization by, at the time, the administering powers of the territories and protectorates of the Pacific in the post-Second World War environment. So Australia, New Zealand, France, the United States, the United Kingdom, and the Netherlands. And over time, the protectorates and territories, many of them have become independent nations and they have joined the Pacific Community. And today we're an intergovernmental organization with 27 member states, also with the specificity of welcoming non-sovereign territories as members of the organization. And the organization provides a range of development services across all 17 Sustainable Development Goals, with the idea of really accompanying and supporting the development aspirations of Pacific Island countries and, of course, Pacific Island peoples. This is the region that we are working in, and this is the region that I will be speaking from and about in large part today. You'll see there, those are the members of the Pacific Community, the island members, all 22 Pacific Island countries and territories from the Micronesian subregion, the Melanesian subregion, and the Polynesian subregion, all of which make up the Pacific Islands. And we have 5, actually, that slide is wrong, my apologies, 5 of our founding members that remain full members of the organization, and you can see them on the screen there, I hope. And what's important to note is that that region there covers this in terms of continental land masses. You can put into the oceanscape of the Pacific Community's membership, Africa, South America, Antarctica, parts of Eastern Europe and the Middle East. It is absolutely vast. And it really is, or could be described as a blue continent. 800,000 square kilometers of land and around 30.5 million square kilometers of exclusive economic zone. And again, to give you some further context that will speak to this notion of climate justice, I hope you'll see later on, that the Pacific Ocean is, or has been characterized as the planet's blue lung. According to some models, it absorbs around 13% of the annual CO2 emissions from fossil fuels and industry every year. It contributes to worldwide food security with over 2.5 million tons of tuna that are caught in Pacific waters each year, and that's 34% of the global annual tuna catch. It's an industry that in 2016 was valued at over 2.5 billion US dollars. The Pacific Islands region is home to 3 of the world's 35 global biodiversity hotspots. It has unique and precious flora and fauna with over 3,200 species on the Iucn Red List of threatened species. It's home to 13 World Heritage Sites throughout the Pacific Islands. And it also matters because from a geopolitical sense, the island countries and territories, plus Australia, France, New Zealand, the UK, and the US, well, many of them are sovereign nations, members of the United Nations, members of the Commonwealth, members of La Francophonie, and other groupings. And so the Pacific has weight, if you like, not only because many of the Pacific Island countries as small island developing states have grouped together with other like nations around the world, but also because of the increasing geostrategic importance of the region, in particular as part of the Indo-Pacific axis. This next slide speaks to the mission of my organization, the Pacific Community. And to deliver on that mission, we really do try to support sustainable development by applying what we call a people-centered approach to science, research, and technology across the breadth of the Sustainable Development Goals. And so we serve our members by interweaving and harnessing the nexus of climate, ocean, land, culture, rights, and good governance through the partnerships that we develop and through investing in Pacific people and understanding Pacific contexts. And so what of the Pacific community and climate justice? Well, the strategic plan that, as a matter of fact, was adopted, the 2021 plus strategic plan of my organization, was adopted less than a month ago by our governing body, and it has placed climate change at the heart of our action and our objectives. It has recognized the climate crisis as the greatest challenge facing our vibrant blue Pacific continent, and you'll see later on why that notion of blue Pacific again is very important. It's identified as its key focus area, number one, resilience and climate action. And it's identified a number of future pathways through climate, disaster risk information, Indigenous knowledge, and the rights and needs of the most vulnerable to inform decision-making, management, and response in multiple sectors. It attempts to integrate climate and climate action across other key focus areas, such as natural resources and biodiversity, food systems, questions of equity, education and social development, economies and livelihoods, health, and it aims at a future state where Pacific people will be thriving with really enhanced resilience from better informed decision-making and the necessary resources that enable the achievement of low carbon, climate resilient, sustainable development. And to give you a sectoral example to help illustrate some of the work that we do, research was published by our fisheries scientists, along with some other scientists from partner organizations, in the journal Nature Sustainability earlier this year. And that research showed that global warming is expected to progressively push tuna populations from the waters of 10 Pacific small island developing states into the high seas, so disrupting island economies. And if ocean warming continues at the current rates, the tuna catch in the combined waters of those countries is expected to decline by an average of 20% by 2050. And 2050 is tomorrow in terms of a timescale. And this here is really a climate justice issue, because those 10 Pacific Island countries have a deep economic dependence on tuna fishing, but they actually contribute little, if anything, to global warming. And in contrast, some of the distant water fishing nations that are responsible for 60% of historical greenhouse gas emissions would actually benefit from the migration of tuna to high seas areas. Lower tuna catches will reduce access fees that contribute to GDP. They'll result probably in a loss of government revenue in the range of anywhere between 8 to 17% by 2050. And when tuna or straddling fish stocks move from an exclusive economic zone of a Pacific Island country to the high seas, it's obviously then far more difficult to enforce the regulations that are designed to sustain the stocks and the economies that rely on them. So the implications of tuna redistribution are potentially extremely severe, and they need to be addressed through cooperative management that is consistent with international legal frameworks. And what's interesting is that the Western and Central Pacific Fisheries Commission, which is the fisheries commission that has been set up to manage the high seas tuna fishery in this part of the world, has already begun to consider such issues, and actually in 2019 adopted a resolution on climate change. One of the other aspects that my organization works on is the legal aspect, issues of climate change and sea level rise, climate migration, statehood and the protection of persons displaced by the climate, by sea level rise, etc. And we don't do this alone. We do it with partner agencies and organizations. One such is the Pacific Islands Forum, which is a political body in the region. We work with the United Nations and UN agencies, and obviously contribute where we can to the work of bodies like the International Law Commission. I myself have had the pleasure of representing SPC on the specialist subcommittee that was set up on sea level rise in relation to international law that helped produce a normative declaration that was adopted by Pacific Island leaders earlier this year, and that I will touch on slightly later. So now we're getting to the heart of what I would like us to discuss today, climate justice. What is climate justice? Well, as many of you probably know, there is actually no single adequate definition of climate justice. But what we find behind that notion is really a multi-sectoral recognition that the impacts of climate change are not equal and they do not affect different groups equally. For example, there are differing social, economic, health, cultural, and human rights impacts among others, to name but a few. Climate justice also recognizes that there's a disproportionate effect on already vulnerable or marginalized communities, whether that's women, indigenous people, disabled people, people of color, youth. And this has been recognized on many occasions, including by the UN Secretary General Antonio Guterres, who said climate change is happening now and to all of us. No country or community is immune. And as is always the case, the poor and vulnerable are the first to suffer and the worst hit. And that last statement is absolutely key when we get into the heart of the notion of climate justice. What's also very important within that notion of climate justice, and very important as well for the Pacific region, is the recognition that many of the greatest victims of climate change also have disproportionately low responsibility for causing the emissions that are responsible for climate change in the first place. For example, the Pacific Islands region contributes less than 0.03% of the world's total greenhouse gas emissions. Yet it's among the most vulnerable to the impacts of climate change. And it has been internationally recognized as being both on the front line of the climate crisis and wielding moral authority when it comes to raising global ambition and driving climate action. In other words, the concept of climate justice has emerged from the idea that historical and current responsibility for climate change lies primarily with the wealthy and the powerful, yet it disproportionately impacts the poorest and the most vulnerable. Climate justice is also, or has evolved into an increasingly significant component of the overall concerns raised by climate change and environmental degradation. The global climate justice movement today that has been pioneered by activists coming from the global south, but is now pushed, carried, and pioneered in the modern sense by many other groups, including from the global north, by school strikers, by civil society groups, by First Peoples and First Nations, indigenous groups. And it's really helped to push not only climate justice, but a notion within it of intergenerational equity, of the need for intergenerational partnerships that help address the possibility and the potential of intergenerational harm and to arrest the potential of that harm. And what climate justice, I think, has really sought to do is to reshape climate action from what was perhaps seen at the outset as really a purely technical effort targeted primarily at reducing emissions into a far more holistic approach that also addresses human rights and social inequalities, among others. Climate justice has also, and I'm delighted to see this, it's also really fully integrated science as a key pillar. It really has harnessed, in particular, for example, the reports of the IPCC. It draws on other scholarly publications to support, and I don't intend this to be an exhaustive list, but to support, first of all, the actual existence of climate change, still denied by some, unfortunately, notwithstanding the very clear science. Second of all, to support the existence of the impacts of climate change, then the harm caused by those impacts, then the potential harm caused by inaction or insufficient action, and finally, the more and more refined attribution of impacts to emitters. And science is key in all of those areas. And in particular, on the latter point, just on, I think, the 9th of December last, the University of Sydney's Australian Centre for Climate and Environmental Law actually held a really fascinating distinguished speaker address entitled, "Can Climate Litigation Save the Planet? The Role of Climate Attribution Science." So we see under climate justice the marriage of the law and science in contributing to justice. There have also been a number of judgments in climate litigation cases that again have pointed to the increasingly critical role of attribution science in support of causes of action related to climate change. Under this notion of climate justice, once again, there's also the recognition of a key principle of international environmental law, that of common but differentiated responsibilities, in that climate justice drives major emitters to rapidly reduce their emissions, whilst understanding that there are populations, particularly in the developing world, who need more time, greater finance, increased technology transfer, etc., to reduce their emissions and shift to the low carbon transition. Climate justice recognizes that to hold such countries or populations to the same standard as developed countries would actually be to place yet another burden on them in addressing the impacts of climate change that they actually have not caused. And there's a great quote by Asad Rehman, who is the executive director of the non-governmental organization War on Want, that captures this quite nicely. And it's, "Fixing the climate is only possible if we also fix all of the other inequalities that exist, because not only does climate reinforce all those things, but it also amplifies them, and it's an expression of those things." And that, I think, really illustrates quite nicely what climate justice is all about. What we've also seen is that, unfortunately, the multiple unfulfilled climate promises at international and domestic level have led those who seek climate justice to turn to the law at international and domestic level to address the ongoing and urgent need for climate action. And while some may argue that the law is an obstacle to climate justice, it might be too rigid, too slow to evolve. Some may say it's not adapted to causes of action that are linked to climate change or not sufficiently coercive. I would argue that the law provides an increasingly broad panel of solutions to climate inaction, and that it is, in fact, another one of the pillars of climate justice. And this takes us to the notion of climate justice and the law. You'll know that contentions over justice actually played a really key role in shaping the UN Framework Convention on Climate Change, the Kyoto Protocol, and the Paris Agreement. And they continue to play out in international and domestic climate politics. And we saw that just as recently as COP26 this year, where many of the long-standing divisions on what justice looks like or should be actually remain, in particular on issues like access to climate finance, on carbon markets, or on loss and damage. However, what's positive, and we have to take the positives, I think, you've got to remain positive in the fight for climate justice, is that the UNFCCC regime does provide a universally recognized global forum for the interaction between climate justice concerns and politics, and therefore for the legal ramifications that flow from that interaction. I'm going to touch on a few points here to help illustrate the point that I'm trying to make around climate justice in the law. The Paris Agreement itself, in its preamble, makes an explicit reference to climate justice in the framework of a much broader perspective. It notes the importance of ensuring the integrity of all ecosystems, including oceans, and the protection of biodiversity, recognized by some cultures as Mother Earth, and noting the importance for some of the concept of climate justice when taking action to address climate change. Now, that's extremely important because it is high-level recognition of the link between climate justice and climate change, but also that notion that climate justice is part of ensuring, guaranteeing, conserving, preserving the integrity of all ecosystems. Added to this is the fact that, as many of you will know, as part of the rule of law in international relations, States, of course, need to abide by their strict obligations under the Paris Agreement, but in addition, they have to help create the broader enabling environment, including at legislative and regulatory level, that facilitates an effective response to the adverse effects of climate change and supports the goals of the Paris Agreement. So this twofold expectation speaks directly to the notion of justice, and of course, in the context of the Paris Agreement, to that of climate justice. We're also seeing that notion of justice really emerging and becoming embedded within the domain of human rights. We've seen the right to a healthy environment enshrined in the constitutions of over 100 countries today, and also recognized formally by the UN Human Rights Council, which just recently established a special rapporteur dedicated to climate change and human rights. And again, high-level recognition by the High Commissioner for Human Rights, Michelle Bachelet, who stated we have to build on this momentum to move beyond the false separation of environmental action and protection of human rights. It's all too clear that neither goal can be achieved without the other. So here, what I think we are seeing is the emergence of the right to a healthy climate and the notion of climate justice, not only as a driver of that momentum, but also as an objective of what it is that overcoming that false separation of environmental action and protection of human rights is trying to attain. And once again, that multi-sectoral approach speaks directly to the notion of justice, and in the context of this seminar, climate justice. Climate litigation is also another absolutely fascinating area where the law has an incredibly important role to play when international or domestic leadership fails to take the requisite level of action. And we've seen this in the absolutely exponential increase in the number of climate cases worldwide over the past decade. The UNEP Climate Litigation Report of 2020, I think, showed around about 884 cases in 24 countries in 2017. And last year noted 1,550 cases filed in 38 countries. The Oxford University's Environmental Change Institute published a report that showed that just over 800 cases were filed between 1986 and 2014, and over 1,000 have been brought in only the last 6 years. And along with that exponential growth in climate litigation, we've actually seen the creative development of strategic causes of action based on constitutional rights, the rights of the child, culture, identity, the actual state of the environment, administrative authorizations, lack of clarity in terms of mitigation objectives, emerging duties of care among just some. And this again shows how very fertile the law is as one of the fields that can help contribute to attaining the goals of climate justice. But at the same time, as we progress, some have also raised the question of a tension between climate litigation and climate justice, in particular as regards the global south. And I find this really interesting because many of you will be aware that some of the landmark climate cases have actually come from the global south. Ligari and the Federation of Pakistan, the Climate Change and Future Generations lawsuit in Colombia, Earth Life Africa Johannesburg from South Africa. And these cases have clearly advanced the cause of climate justice. They've provided inspiration and guidance and strategy for further climate litigation in other jurisdictions as well as in their home jurisdictions. And one of the salient features is that they're often based on the use of human and constitutional rights. And obviously, the positive outcomes are based on the responsiveness of domestic courts to these arguments. But at the same time as the courts have accepted the rights-based or the constitutional arguments of plaintiffs in these cases, they've also ordered remedies, such as injunctions against the defendant state, or specific performance of measures that are aimed at ceasing or preventing harm, creation of specialized boards to enforce existing policies through action plans, et cetera, et cetera. And it's actually around the issue of remedies that the tension between the outcomes of climate litigation and climate justice has been highlighted. Because whilst litigators have won court cases based on human rights and constitutional law, the states that need to offer the remedies are generally not states that are major contributors to global greenhouse gas emissions. And at the same time, these countries often do not possess the structural capabilities to implement the ambitious and comprehensive remedies that the courts order. And again, we're in the situation where they did not engender, nor have they really furthered the global climate crisis, but they are disproportionately impacted by it. And this is where, again, there's that tension between advancing the cause of climate justice through climate litigation and perhaps adding a burden through the nature of the remedies that are imposed by domestic courts, in particular, once again, in countries in the global south. As part of this discussion on climate litigation, I think it's absolutely fascinating as well to see the emerging body of transnational environmental law, of which climate law is a significant aspect today. There's really increasing momentum in transnational, sub-state, and private climate governance as well, which opens up some new and important dimensions of climate justice across multiple scales, from boards of directors providing instruction to divest investment portfolios that are linked to extractive industries, to regions and cities taking climate policy decisions that are sometimes more ambitious than the decisions of their nation state. The work that's been done in investment treaty arbitration sometimes to address issues of climate justice and climate change. And some climate cases, including very recent ones, that have recognized new duties of care to populations, not only on the part of public actors, but also private industry. And another significant aspect and significant evolution and potentially revolution are the criminal aspects of the law in the context of climate justice, and in particular, the notion of ecocide. The Stop Ecocide Foundation's initiative and the historic definition of ecocide that was drawn up just this year by legal experts from around the globe, with the hope that it be adopted by the International Criminal Court to allow prosecution of the most egregious offenses against the environment. And you'll see that the proposed definition of ecocide, while it doesn't specifically mention climate change, does aim at unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and widespread or long-term damage to the environment being caused by those acts. And Professor Philippe Sands, QC, who was one of the drafters, indicated that this really introduces a new non-anthropocentric approach. It puts the environment at the heart of international law so that it's original and innovative. And it's part of the broader process of changing public consciousness, recognizing that we're in a relationship with our environment. We're dependent on our environment for our well-being, and we have to use the various instruments, whether they're political, diplomatic, and or legal, to achieve the protection of the environment. And so when you look at this notion of climate justice and ecocide, or climate change and ecocide, you can see how, given the attribution science, given what we know of the current and ongoing effects, the current harms and the potential harms, how well climate change would fit within the ecocide context and within the ecocide definition, should that be adopted and should the issue go to court one day. Also, again, there's the role of the judiciary. In order to advance on this plane, one needs the judiciary and an active judiciary. And to very liberally paraphrase New Zealand's Chief Justice, there is a need to renovate the house of the law in order to better address climate change and climate justice as the most pressing issue of our time. And that's to evolve at international level, at constitutional level, within torts, within human rights. It's a multiple facet evolution of the law to address the multiple and cross-cutting adverse effects of climate change. The lack of ambition, the lack of action, the lack of accountability on the part of those who contribute to greenhouse gas emissions and other related forms of environmental degradation. And if one accepts that the interface between the law and harms flowing from climate change is currently unsatisfactory, then it is perhaps really time for the courts, and some of them are doing this, but to help establish the machinery by which an appropriate remedy can be found. I'd suggest that strengthening this approach should embrace international, regional, and domestic instruments, and that this role of the courts and the judiciary, alongside that of litigants and counsel who bring and plead climate cases, would contribute significantly to actually crafting the means and setting the precedents that help the law evolve, thereby creating the legal framework that's required for future cases to be decided. Now, some may say that this particular opinion smacks of a call to judicial activism, but I would place it in the context of an emerging narrative that gives place and meaning to a necessarily evolving legal paradigm. In his work, Nomos and Narrative, Robert Cover stated that no set of legal institutions or prescriptions exists apart from narratives that locate it and give it meaning. For every constitution, there is an epic. For each decalogue, a scripture. Once understood in the context of the narratives that give it meaning, law becomes not merely a system of rules to be observed, but a world in which we live. Now, climate change and the fight for climate justice, at least in popular opinion and to some degree in widely publicized political opinion, could be considered the overarching existential narrative of our time. And in this context, I would argue that the law must adapt as both a facet of and a participant in the ongoing development of that narrative. And in so adapting to embrace the climate change narrative and address the challenges that are posed by climate litigation, the law would acquire new sense, meaning, and relevance as our overarching nomos, as Cover said, an integrated world of obligation and reality from which the rest of the world is perceived. And so evolution of the law in this broad area, including to embrace, for example, the liability of non-state actors, would appear, at least to me, not only to support the objectives of many countries' statutory climate change regimes, but also those of the overriding policy commitments that have been made by parties to the Paris Agreement and other international climate instruments. And it would really be disingenuous to claim that these commitments are merely political and that accountability for meeting them or failing to meet them only lies with the government of the day. That would actually relieve industry, commercial interests, and private citizens of any duty whatsoever to contribute to the actions required to fulfill that goal, just as it would relieve them of any liability for actions that through their effects slow or undermine the rate of progress required or exacerbate the harm to others, and thus run counter not only to decisions at national and international level, but also to the voice of the people as expressed through decisions and commitments made by their elected representatives. And I think it's really important here to remember that the goals set in the Paris Agreement and the global push to reduce greenhouse gas emissions or invest massively in mitigation and adaptation, transforming economic models into viable options for low carbon development, all of that has not been done for the benefit of the ether. It has been done to avoid the science-based projections of significant harm being done to humankind through the negative effects of climate change on the ecosystems that support life on Earth, that support food and water security, human health and well-being, cultural integrity, and support also avoiding conflict and human security risks, to name only a few. So through interpretation, adaptation, and application of the law, I would submit that the judiciary most certainly has a role to play in helping achieve those policy goals and in reducing or avoiding the harm, the loss and damage that may be suffered as a result of inaction, insufficient action, or actions that contribute to negative impacts on the climate and the environment. And in doing so, the judiciary would really be contributing not only to the evolution of the law, but also to enhancing the environmental rule of law, positioning the courts as an actor in the evolving societal narrative of climate change and climate justice as the most pressing issue of this age. And for those of you who are interested, the Iucn Environmental Declaration, World Declaration on the Environmental Rule of Law, the link's up on the screen. It's an absolutely fascinating document that demonstrates how important the environment is as part of the rule of law, and that speaks once again to the multifaceted, transboundary, cross-cutting issue of environmental harm, in which climate change is one of the major actors. And now to some strictly Pacific perspectives. The image that's on your screen is taken from a conference that was convened by my organization in 1992, coincidentally the same year that the UNFCCC was opened for signature at the Rio Convention. And this conference was already 30 years ago on the effects of sea level rise, a major issue already identified back then for the countries and peoples of the Pacific. Sea level rise induced by climate change. And so this takes me to the Pacific and climate justice. Now you see the slide on sea level rise. I'll touch on it again slightly later, but I'm going to take you through some key instruments from the Pacific, key declarations that demonstrate how the Pacific has internalized climate justice as part of its development paradigm and as part of how it projects its ambitions for sustainable development and a sustainable future on the international stage. The first of those is the Bowie Declaration on Regional Security, which was adopted by leaders of the Pacific Islands Forum. Now, you may wonder what regional security has to do with climate justice, but this particular declaration recognizes an expanded concept of security that's inclusive of human security, humanitarian assistance, environmental security, and regional cooperation in building resilience to disasters and climate change. It reaffirms climate change as the single greatest threat to the livelihoods, security, and well-beings of the Pacific. And it reaffirms the commitment of Pacific Island countries and their partners in the Pacific Islands Forum to progress the implementation of the Paris Agreement. It also affirms stewardship, the Pacific's countries' stewardship of what they call the Blue Pacific. And again, I'll explain what that means exactly in a short while. This was followed up, I think a year or 2 years later, by the Kainakilua Declaration for Urgent Climate Action at the Tuvalu Pacific Islands Forum, when the UN Secretary General visited the Pacific and saw firsthand the impacts and implications of the climate change crisis on the Pacific. And again, this declaration recognizes that climate change and disasters are impacting all of our countries in the region. Seas are rising, oceans are warming, extreme weather events such as cyclones and typhoons, flooding, drought, and king tides are more intense, they inflict more damage, and they're destroying communities and ecosystems and putting the health of Pacific peoples at risk. It recognizes the fact that all around the world, people are being affected by disaster and climate change-induced displacement. They're losing their homes and their livelihoods, in particular, the most vulnerable atoll nations. Again, it welcomes the science, it welcomes the work of the IPCC. And it says that the shared prosperity and security of our Blue Pacific can only safely exist if the international community pursues efforts to limit global warming to 1.5 degrees Celsius above pre-industrial levels as set out in the Paris Agreement. And that there speaks directly to that notion of climate justice, interregional equity, intergenerational equity, the obligation of those who contribute to help those who do not contribute to global warming survive its impact. The Blue Pacific is, again, something that's extremely interesting from a climate justice perspective in the region, because what that has done is to place the Pacific Ocean at the heart of the political and development narrative of the Pacific Islands region. There's a 2050 strategy for the Blue Pacific continent that's being developed right now as a long-term vision for the region, and that will outline the steps to achieve this vision. So a regional strategy to protect and secure the future for Pacific peoples. And it's a unique opportunity for the region to develop long-term approaches to challenges such as climate change, sustainable development, and security. In this context, what it does is it recognizes that for the Pacific and the island countries and populations, the ocean is absolutely crucial. It recognizes that exercising a sense of common identity and purpose linked to the ocean is critical for protecting and promoting the potential of what they call our shared Pacific Ocean. And it looks to strengthen existing policy frameworks that will harness the ocean as a driver of transformative socio-cultural, political, and economic development in the region. The Blue Pacific behind that seeks to recapture the collective potential of Pacific Island countries and peoples' shared stewardship of the Pacific Ocean, based on the explicit recognition of shared ocean identity, shared ocean geography, and shared ocean resources. It puts the Blue Pacific, the ocean, the identity of the peoples at the center of policymaking. So the environment at the center of policymaking and collective action for advancing the vision for the region. And what this means, above and beyond the political declarations and what it can mean for development, but from a cultural and an identity perspective. And again, linking this to the climate justice context, multi-sectoral, human rights, etc. This has been captured absolutely beautifully by a famous Tongan Fijian author, a gentleman, unfortunately, who has now passed, called Epeli Hau'ofa. And he said of the identity of Pacific Island peoples, Oceania is vast. Oceania is expanding. Oceania is hospitable and generous. Oceania is humanity, rising from the depths of brine and regions of fire deeper still. Oceania is us. We are the sea. We are the ocean. We must wake up to this ancient truth. And so all of this, I hope, provides you with context to illustrate why climate justice is so important in the Pacific. It's not just for reasons of international or regional commitments or to advance towards the Sustainable Development Goals. It's actually essential to maintaining, preserving, and strengthening the Pacific as an ocean continent and Pacific people's very identity, which has the ocean at its heart. You'll remember that I said earlier that the Pacific only contributed 0.03% of global greenhouse gas emissions. So even if the entire Pacific moved to zero carbon tomorrow, it would literally and figuratively be a drop in the ocean. Climate justice would require large industrialized countries to rapidly and urgently take the mitigation action that would be required to render sustainable the adaptation measures being taken right now in Pacific Island countries. Because without that, the science we have demonstrates that we will reach the limits of sustainable adaptation to climate change in the not too distant future. And with that, there are a multitude of threats, including that of climate-induced displacement. And some models anticipate between 665,000 and 1.7 million individuals could be displaced in the Pacific region due to the effects of climate change by 2050. So in other words, between 665,000 and 1.7 million people in the Pacific Islands region alone, through no fault of their own, could be driven from their ancestral homes, their sacred places, and from the land and the ocean to which they're so deeply bound and of which they're the traditional custodians. And without urgent climate action from the global community, as land masses are submerged by sea level rise, this will raise the question of the permanence of established maritime boundaries, sovereignty and sovereign rights exercised by states within and beyond those limits. And as such, the Pacific Islands region, Oceania, is actually likely to have the very sad privilege of being a testing ground for a new chapter in international law as the international community adapts to both people and potentially states in climate-enforced exile. So in this context, climate justice really needs an integrated approach that takes into account, among others, political, social, cultural, environmental, and legal aspects. It requires a whole of society approach, together with very strong international cooperation, to identify and implement solutions, in particular solutions that not only protect the environment, but also protect the rights of all persons. And in the context of potential climate displacement, those rights are both those of displaced populations and the populations that welcome them. They'll need to anticipate, for example, the preservation of rights such as those related to culture, identity, freedom of religion, access to employment, or resources, or even self-determination. And should some island countries become uninhabitable, again, they'll need to anticipate the extreme hypothesis of, as I've said, a state in climate-enforced exile, and the very complex ramifications for sovereignty, nationhood, and rights over land-based and marine natural resources. And this is one of the drivers that led the Pacific region and Pacific leaders to develop and adopt a normative declaration on preserving maritime zones in the face of climate change-related sea level rise. And that was done just this year. This was done by Pacific Islands Forum countries, leaders, so the prime ministers and presidents, and it was supported by a specialist subcommittee that was set up on sea level rise in relation to international law. The whole of this declaration is based on compatibility with the UN Convention on the Law of the Sea, but also, again, in the context of climate justice, on the principles of equity, fairness, and justice as key legal principles that underpin UNCLOS. The declaration draws a direct line between climate change related sea level rise and maritime zones. And it understands that this wasn't contemplated at the time that the Convention on the Law of the Sea was drafted and negotiated. But it underscores that today, small island developing states in particular, and coastal states and low-lying states are especially affected by sea level rise and climate change, and that they've planned their development in reliance on the permanence of the rights to their maritime zones that are guaranteed in the Convention. Therefore, the threat of climate change and sea level rise are a defining issue that imperils the livelihoods and the well-being of the people in those countries and their possibilities for the full realization of a sustainable future. And so it records from a normative declaration perspective to support future legal developments, the position of those countries that maintaining maritime zones established in accordance with UNCLOS and the rights and entitlements that flow from them, notwithstanding climate change sea level rise, is supported by both the Convention and the legal principles underpinning it. And it says specifically that those countries intend to maintain those maritime zones without reduction, notwithstanding climate change related sea level rise, and they do not intend to review and update their baselines and outer limits as a consequence of climate change and sea level rise, and therefore that their maritime zones, as established and notified to the Secretary General of the United Nations in accordance with UNCLOS, and obviously the rights and entitlements that flow from them, shall continue to apply without reduction, notwithstanding any physical changes connected to climate change related sea level rise. So again, it's a formal statement of Pacific Islands Forum members' view on how the United Nations Convention on the Law of the Sea would apply in the situation of climate change and sea level rise. And it's intended not only to draw a line in the sand from the Pacific's perspective, but also to help shape the ongoing international discussions on this issue, including the work of the International Law Commission, which the Pacific Islands Forum and my organization and many others in the region actively support. And I'd also mention that we're actually supporting submissions on issues of interest for the ILC on the subtopics of statehood and the protection of people affected by sea level rise. Other aspects of the Pacific and climate justice are the widely publicized call from Vanuatu to request an advisory opinion from the International Court of Justice on the rights of present and future generations to be protected from climate change. And here it's interesting to note that, yes, the call came from Vanuatu as a member state of the UN, but this call for an advisory opinion has been carried for years by the Pacific Islands students fighting climate change movement. So a group of students, a group of young activists that pushed for this because what their hope is that the opinion will assist with climate litigation cases around the world, that it would be a catalyst to bolster and advance progress in the fight for climate justice. And interestingly enough, the declaration from Vanuatu actually came just after the first Pacific Climate Justice Summit took place in August of this year in the region. And again, that's where there was a call for an advisory opinion, and a number of partners were there to provide analysis, thought leadership to advance this particular call, but also other means to look for pathways to climate justice. It's incumbent upon me when we're talking about advisory opinions, just to remind everyone as well that there have been other initiatives from the Pacific in this space. In 2002, Tuvalu, for example, threatened to actually bring a suit in the ICJ in response to the United States intransigence at the time on emissions reductions. And later on, Palau led efforts with a coalition of vulnerable states to try and request another advisory opinion from the ICJ on the responsibilities of states under international law to ensure that activities carried out under their jurisdiction or control that emit greenhouse gases do not damage other states. But unfortunately, neither of those initiatives advanced beyond early stages for a number of reasons, of which political pressure may well have been one. Interestingly enough, beyond the International Court of Justice, there's also just been announced in the wings of COP26, a joint initiative launched by the prime ministers of Antigua and Barbuda and Tuvalu to establish a commission of small island developing states on climate change and international law. And one of the primary concerns of this future commission would be to request an advisory opinion from the International Tribunal on the Law of the Sea concerning climate change, sea level rise, protection of marine environment, and international responsibilities. Now, that's fascinating because, again, we're seeing various jurisdictions being approached or thought of as potential alternative or parallel pathways to find the means to get the responses that countries are looking for to take climate action forward, to create new momentum, and obviously to achieve the goals of climate justice. And as regards the ITLOS advisory opinion, as things stand right now, the exact strategy, including the potential questions that would be put before the tribunal, have yet to be developed by the Commission. And finally, what about climate litigation in the Pacific, given everything that I've just said about how important climate justice is? Well, it's actually surprising. There are comparatively few cases, given the priority at political and civil society level that has been given to climate change, climate action, and climate justice. And from what I've been able to see during my research, there are actually no cases in the Pacific Islands region right now, no climate litigation cases. There are, however, and there have been some interesting examples from around the region, the periphery. One is the current Torres Strait Islanders and Government of Australia petition to the UN Human Rights Committee, which alleges that Australia is violating the rights of the fundamental human rights to culture, to freedom from arbitrary interference with privacy, family, and home, and the right to life of the people inhabiting the Torres Strait Islands under the International Covenant on Civil and Political Rights, due to the Government of Australia's failure to address climate change. Now, this is the first legal action that has been filed with a UN body by inhabitants of low-lying islands against the national government for inaction on climate change. And it will be interesting to see how the UN Human Rights Committee approaches this, what its analysis is. And interestingly enough, this international petition has actually just been followed by a domestic class action in Australia from 2 First Nations leaders from the Torres Strait Islands that challenge what they call Australia's failure to cut emissions, and asserts that the government's inaction will force their communities to migrate to new areas, and that there is a duty of care to take reasonable steps to protect them, their culture, their traditional way of life, and their environment from the harms caused by climate change. And that this duty of care has been breached because the Australian government's targets are not consistent with the best available science. Another interesting case that deals with the region, but actually flows from actions in New Zealand, was the petition by a Kiribati national, Ioane Teitiota, to the UN Human Rights Committee, contesting his return to Kiribati after refusal of his application for refugee status by New Zealand authorities. And again, the petitioner here based his claims on the violation of the right to life, claiming that the effects of climate change and sea level rise had forced him to migrate from Tarawa, which is the main island in Kiribati, to New Zealand, and that returning him there exposed him and his family to a precarious life due to sea level rise caused by global warming. There was not enough fresh water. There was overcrowding. Attempts to adapt had been largely ineffective, and therefore that had placed pressure on populations, a housing crisis, land disputes, conflict that he would have been exposed to on his return. And while the committee did not conclude that there'd been a violation of the right to life under the Covenant on Civil and Political Rights, it did accept the petitioner's claim that sea level rise is likely to render the Republic of Kiribati uninhabitable at some time in the future. It did state that without robust national and international efforts, the effects of climate change in receiving states may expose individuals to a violation of their rights under Articles 6 and 7 of the Covenant, and that would trigger the non-refoulement obligations of sending states. And it recalled that environmental degradation, climate change, and unsustainable development constitute some of the most pressing and serious threats to the ability of present and future generations to enjoy the right to life. So again, very clearly, the committee was conscious of a number of notions that speak directly to the cause of climate justice. And the last case that I'll briefly touch on is Smith and Fonterra. It's a New Zealand case brought by Mr. Mike Smith, who is a tribal elder of the Maori people in New Zealand, who was seeking recognition from the courts of a new duty of care that would be owed by private companies, in this case 7 New Zealand companies, to reduce radically their greenhouse gas emissions or activities that contribute to those. He alleged, for example, that poor and minority communities would be disproportionately burdened by the adverse impacts of these activities. And again, he pled under the law of tort 3 claims: public nuisance, negligence, and the new tort of a breach of duty of care. Now, unfortunately, in my opinion, the New Zealand Court of Appeal considered that to recognize the new duty of care would be far too radical a response, and it was contrary to the common law's tradition, which is one of incremental development. And this was true, said the Court of Appeal, in this case, because it would require a departure from fundamental principles, and it would have eventuated in recognizing a scenario where almost every person in New Zealand or the world to varying degrees would be seen as responsible for causing harm and also a victim of that harm. And it was impossible, said the court, to identify a principled basis for singling out any small group of companies or people responsible for the overarching effects of climate change. And again, interesting for the principles underpinning it, and demonstrates that there is as yet a need to continue with climate litigation to help contribute to that incremental change that is needed by an issue which is actually urgent in its call for and need for action on the ground. So in the Pacific, climate litigation is actually an underutilized tool in the fight for climate justice. And given, for example, the principle under international environmental law of equality of access to justice, one could really imagine there are multiple opportunities for strategic climate change litigation brought by Pacific Islanders based on issues of transboundary harm or rights or lack of action and ambition, not meeting international domestic legal obligations. All of this underpinned by science, assisted by attribution science, and supported by the very strong and undeniable cultural and identity ties to land, sea, and resources. There's a real possibility here to draw on cases that have taken place elsewhere. Just a few come to mind: Iucn, the Affaire du siècle in France, the Friends of the Irish Environment, the recent German Constitutional Court case, even the Supreme Court of Colombia's jurisprudence on the rights of the Amazon rainforest. I mean, can you imagine a climate case brought by Pacific Island communities based on their own rights, but also those of the Pacific Ocean? There's some real power to be harnessed in climate litigation in the Pacific region to advance the cause of climate justice. So in conclusion, I really hope this illustrates why climate justice is important, not only for the Pacific, but globally, and provide you with examples of the efforts that remain before justice can truly be realized in the context of international and national regimes of environmental governance, and the role that the law can play in advancing the cause of climate justice alongside policy, science, and continued activism. Whether at international, regional, or national level, statements on and commitments to climate action or climate justice are just that if they're not backed up by real actions and outcomes. They're simply ink on paper or verbal declarations. And the law can and should, in my view, whether via the legislator, a proactive judiciary, or climate litigants, continue to play an increasingly important role in holding governments, business leaders, and others to account for their statements, and also for translating political or business rhetoric into tangible outcomes that actually address the multifaceted effects of climate change and the multidimensional nature of climate justice. Without such tangible outcomes, we will not keep 1.5 degrees alive. We will not deliver on the promise of the Paris Agreement, and we certainly won't be responding to the clause of climate justice. As one of the levers to help bring those outcomes about, as one of the pillars of climate justice, the law can really play a critical role in addressing the defining issue of our time and affording a chance to deliver on a new deal for nature and people and a sustainable future for the countries and peoples of the Pacific and many more around the globe. Thank you very much for your patience and for your attention.
Thank you so much, Mr. Diver, for this absolutely fascinating and comprehensive lecture on climate justice, and also sharing the perspectives and concerns of Pacific region. Actually, I have learned a lot from your presentation, and I'm sure our participants have also did. And now we can start questions and discussion session and take the questions. And Ms. Ece will help us for taking the questions.
Sure. First of all, thank you again, Mr. Diver. It was a really fascinating presentation. We have received some questions, and I also have a question, but I'll start with the received ones first, and we can have new questions as well from our participants. First question is, what do you think about the protection of climate migrants under international refugee law and the non-refoulement principle? I guess you briefly mentioned this issue in your presentation, but this question arrived earlier.
Right, thank you. What I think about it is that we really need to anticipate it and start to build the architecture that will allow us to address it. What we saw very briefly, because I glossed over it in the decision of the UN Human Rights Committee, is that there is a recognition that this needs to be dealt with, and that it can trigger the non-refoulement obligation. And if it triggers that, it will trigger a number of other obligations. There is a recognition that the effects of climate change can be so severe that they will be a recognized threat to the right to life, for example, under the covenant. And if that's the case, we can't wait. Well, we can, but I do not think we can afford to wait before we actually start making the changes and the evolutions in both institutional and domestic regimes that will allow the international community and national communities to adapt to what that means to have displaced people coming internationally. Now, obviously, this can also be an issue domestically. In a Pacific environment, for example, you have people from outer islands that will be coming to main islands. And they're all nationals of the same country, but they have a sense of almost subnational belonging. And so what happens when you get someone from an outer island that comes to a main area and they have no rights to land? Their culture is seen as being different and distinct. They're not part of the same tribal group. You need to make the societal changes before that, sensitize people to what it will mean. Otherwise, you're exposing yourself above and beyond the legal risks to risks of conflict over water, conflict over housing, conflict over access to education or employment. And so this issue of climate migrants is a domestic issue. It's an international issue. And again, the law is one of the levers that can help address it, but it really is a societal question. And given what we've seen around the anticipated impacts by 2050, and that's only in the Pacific region, I know there are other regions that are just as affected potentially, or are affected currently even by this. We need to start tooling ourselves up to enable us to deal with it and to ensure that in doing so, we do maintain equity, equality, fairness, and justice.
And thank you, Mr. Dyer. And this question was from Zeynep Ertuğral. We want to thank you to Ms. Ertuğral. And the second question is from Ece Saygılar. And the question is, how would you evaluate environmental racism in the context of climate justice?
Is that how would I address environmental racism?
How would you evaluate environmental racism in the context of climate justice?
Environmental racism is tricky. It's tricky also because I'm a 46-year-old white male speaking on this issue, and where I come from on issues of racism full stop and environmental racism may not be where other people with other experiences, other cultures and backgrounds are coming from. I think it's important to preface any response with that. I also think that sometimes as well, and this is why it's been so important to see the cases coming and being pled by experts from the global south in climate litigation. When you have somebody from the global north who is translating into an environmental cause of action concepts from the global south, sometimes there is even unconscious bias in the way that it's put across. And this, I think, is where there's some wonderful opportunities for capacity building and cooperation. There are wonderful opportunities also for South-South cooperation in this field to bring expertise in so that the paradigm through which environmental causes of action are being promoted is indeed an adapted paradigm and not sometimes slightly artificial. I also think that it's important to continue to educate everybody on these issues so that we all become more and more sensitive to it and can be seen as equally as legitimate to take forward causes of action, whatever our origin and culture may be, when what is important at the heart of it is the commitment to ensuring that the right result is attained in the end. And so I think that, again, the question of environmental racism in solutions, in some of the inequities that I talked about earlier, you know, the disproportionate burden that can be placed on countries by their own courts sometimes. I realize that that's not necessarily racism, but it may be if you're in the higher courts of a country whose judges come from elsewhere. And that is sometimes the case in the developing world. And so again, that can be an imposed paradigm with conscious or unconscious bias. So I think, again, it's about education. It's about legal education coming from the lawyer's perspective, but it's about societal education. And it's about ensuring that, again, this the fight for climate justice, the fight for environmental justice, is seen as a whole of society approach, so that you can use the social sciences to come in and help advance on some of the very tricky issues and the very sensitive issues like racism or gender inequities as well, to name another.
Thank you, Mr. Diver. And waiting for the new questions, I want to ask my question this time. It is about the climate litigation, actually. My PhD thesis that I'm currently working on covers jurisdiction and applicable law issues of climate litigation. But with your presentation, a question came into my mind about the long-term results of climate litigation, actually. And my question is that, can climate litigation, especially cases against corporations and persons, force corporations to create a code of conduct in terms of protecting the environment and with the climate? Or is there a possibility for the emergence of a new system like harm if you can pay for it at the end, as we are talking about very huge sectors and waste sums? And I'm asking for your foresight. Thank you.
Thank you. Look, again, this is my opinion. I don't have the tablets of the law that have been handed down to me on this. So it is just one opinion among many. I think it would be really unfortunate if we came to a harm if you can pay for it result. That would be a little like just allowing everybody to do carbon offsets and not moving towards net reductions in CO2 emissions, for example. So I think that climate litigation can and has already, for certain corporations, been a wake-up call and driven them to develop these codes of conduct around environmental responsibility and harm. You almost see no corporations today that don't have a social and environmental responsibility policy. By the same token, you don't see any intergovernmental organizations like mine that don't have one now, when that in yesteryear that perhaps was not true. And so there really is a realization that one's activities and operations do need to integrate the environmental dimension into it today, because the power of climate litigation is that it is a legal translation of the societal awareness of climate justice. And if I am selling a product and I don't have these environmental safeguards in place internally, then those same people who are calling for climate justice are also my clients, and I can lose them. And so yes, there's an economic incentive, but that has a virtuous, or it can have a virtuous effect in absolute terms as we go down the track. And I know that I'm not naive enough to think that everybody sticks by that or that everybody is playing the game. But I definitely think that there is a significant role for the law in helping push everybody to play the game, to be held accountable. And this is where I think there's huge growth potential in climate litigation aimed at private citizens and private corporations, and particularly, large industrials to start with, to ensure that they are held accountable, and that we don't just get into a situation, which is too often the case, where one considers that it's the nation states, it's the subjects of public law that are the only ones we can hold accountable, because it's just too hard to be able to attribute it to private actors. And I think that saying it's just too hard isn't a good enough argument today, given the urgency of the climate crisis. And the law has a role to play in evolving perhaps far more swiftly than incrementally, so that law and society are in alignment in the swiftness of their response.
Thank you so much for your answer. And there's a question from Mr. Nathan Brown. I hope I pronounce it right. And the floor is yours, Mr. Brown.
Thank you very much.
I guess you're muted now.
That's okay now? Okay. You made reference to the developing world, and so coming from Africa, let me just take that chance and shoot. I think over time we have tended to ignore the disparities that exist within spheres of operation, from continent to continent. So you'll find the levels of understanding, appreciation of the crises that affect continents, the levels differ. And so you find we have almost compartmentalized climate change into European, Asian, African. And so we speak from perspectives to issues depending on where we come from and depending on how we would like to respond. And you'll find activists coming in from various parts of the world to articulate the issues as they understand them from their perspectives, from their continents, from their jurisdictions. I mean, we saw what happened not too long ago during the global summit in Glasgow. So my concern is how we could, I guess it's not even a concern, it's not even a question, it's to throw it to you, sir, but to all of us. How are we going to galvanize the various perspectives and levels of appreciation and take them into a much more globalized approach? Take the example of funding, for example, when we started a lot of work under the Convention of Biological Diversity in 1992, and I have been following this ever since, we created what is really known today as the Global Environment Facility to cater for all these issues. And I don't not myself see if we shouldn't be taking that route for climate change. It seems to me, and that's really disappointing, to be a one-off. We will have an international conference and wait for another period and then troop into the capitals of the world to hold a similar meeting. And yet climate change is real. I come from a part of the world in Africa. Look up north, Turkana is just today that they just got a first well where they're able to get water from. It is difficult. Parts of northern Kenya, animals are dying by the hour. So they feel it, they have no access to water, they have access to no resource. Agriculture is a no-go zone, they just cannot practice that. So I almost suggesting that there might be a need for a Marshall Plan in order to have some sort of equilibrium. We may never achieve equality and equity, as you just said, but how then we proceed from here? That's why I said it's not a question, it's something I'm throwing to the floor. And first of all, thank you for a wonderful presentation. I missed part of it because I was trying to log in from Nairobi, and I'm sure we will have a side chat. I hope I'll get access to your contact and we can proceed from here. Please shoot and let's take it from there. Thank you.
Thank you very much. It's wonderful to see interest from Africa in a discussion on a subject that I know is global, but with some perspectives from the Pacific region. Look, you're right. I don't have the answer to that question. I only have thoughts like you and suggestions. I think one of the, look, you mentioned the Global Environment Facility for biodiversity, for example. I think one of the efforts that was attempted at international multilateral level to help address climate change globally in terms of access to finance or equal access to finance was the Green Climate Fund. Now, the issue with this, and again, I certainly don't mean to criticize the fund. My organization is an accredited entity to the GCF and we work constructively with them. But when you set up a fund, you set up a whole lot of conditions to get access to that. And what we've noticed, and this again from a Pacific perspective, but I imagine it's the same elsewhere, is that many countries in the developing world simply don't have the capacity to jump through the number of administrative hoops that are necessary to access the finance that they need to build a dam or to dig the wells that you were talking about, or to take the adaptation or mitigation action that they want to do. And that's a genuine problem of equity and of justice. It's we've put something in place, the objective is noble, but the processes are sometimes so difficult to work with from a capacity perspective that we are cutting off, or we are making it so slow to get access to that finance that the crisis is doubling in its effects, and the ability to address those, because it takes money and effort and resources to do that, simply is trickling through rather than flowing through in the flood that the urgency would require. I think one of the perspectives from a a legal perspective on how we can perhaps decompartmentalize what it is that we're doing in different parts of the world, is linked to that notion that I talked about a little earlier on the growing body of transnational environmental law, where cases and approaches from one jurisdiction are being taken on board in other jurisdictions. They cross-fertilize the way litigants and lawyers are thinking about approaching their courts or the courts of other jurisdictions. And so solutions from Africa can be taken and developed into a case in the Pacific. Solutions from the Netherlands can be taken and applied in South America and vice versa. And I think that as events like this are important because they create these global networks of interested parties that help break down the silos or make the silos permeable to one another so that they do cross-fertilize and we get there. Perhaps what we need, there is an annual summit on climate change. Perhaps what we need is an annual summit and an ongoing international work program on climate justice, of which the outcomes of the climate summit contribute to, but that is so much vaster in what it is that it tries to capture because of that notion, that multi-sectoral societal notion of justice that's in there. And we try and bring people together, not just intergovernmental, but civil society, the actors that make it work on all levels. And again, that takes time, that takes resources, that takes political will. But I think that there's a groundswell, a worldwide groundswell that we could harness to push towards something like that. And again, it takes a small brick to build a wall, to build a mountain, to get to where we're going. And I think every little thing counts, and we need to remain, I think, positive, enthusiastic. There are great opportunities there to help us address the magnitude of the challenge. I'm sorry, this is a really incomplete response, and it's a little bit of a brain dump, but your question is truly, I think, absolutely vital, and others may well have perspectives on this as well.
I just one last bit, the final link to that. When we had I want us to establish a link between the various spheres we have. So we have the ocean space, which is very critical. I didn't hear this being addressed during the first international sustainable blue economy conference that was held in Nairobi in November 2018. And we are now going to Portugal for the second phase, which is going to be hosted by Portugal. It's a global conference. You will see that there's a lot going on in the ocean space. We are discussing more to do with the land terrain and the airspace. How do we, or how shouldn't we combine these three spheres so that we are able to speak from the same page? Because what affects the air affects land and affects water. And so there probably might be a need to develop a cross-cutting regime of international policy and legislative framework that would speak. So I invite you to consider the possibility that when we have this discussion, you could be exporting this to the next conference in Portugal and speak authoritatively, probably obviously under the KHAS University arrangement. So it's again something to think through, but if you have a quick answer, I'll be very happy. And thank you for responding to my question. So thank you.
Thank you. Look, you've raised another great issue again. I think one of the great opportunities we have is that right now we're in the final decade of the 2030 agenda. And globally, we are not going to achieve the goals of the Sustainable Development Goals or the outcomes of the Sustainable Development Goals if we don't bring all of the development agendas together in a far more integrated way. If we just advance on biodiversity, we'll miss things on oceans. If we just advance on oceans, we'll miss things on rights. If we just advance on rights, we'll miss things on something. And in the end, instead of leaving no one behind, we will leave millions behind. And I think this is an opportunity to raise that level of awareness at political level, domestically, internationally, and elsewhere, to say, okay, let's bring, as we've tried to do in the SBSTA process in the UNFCCC, the visibility and a work program to the ocean climate nexus. But we need an ocean climate biodiversity nexus, and then we need a nexus with something else so that we can bring it all together and take those global work programs forward with experts in each area, but being permeable once again to one another. And look, I'm certainly happy to speak to this on any opportunity that I have, because we see it in the Pacific. Okay, the health of the ocean is absolutely critical for the health of people who are living on land. What happens in terms of plastic pollution in the Great Asian rivers has a direct effect on ocean health, that has an effect on fish stocks, that has an effect on coastal livelihoods, and therefore on health and well-being of communities. It's all joined up, it's not silos. And I do think that we sometimes have a tendency to silo things. And right now the approach that we should have, and it's far easier to say than to do, is to try and integrate that back in so that we have multiple angles of attack and multiple impact outcomes.
Thank you, Mr. Diver. Any other questions from our participants? I guess now, so I may leave the floor to Professor Iucn.
Yes, thank you. Yes, now we have come to the end of time allocated to this event. I would like to thank everyone in the audience for their insightful questions and comments, and for the answers to Mr. Diver. And I hope everyone enjoyed today's lecture. We wish you stick with us during the next month with our 4th seminar. And before finishing, I would like to leave the floor once again to Mr. Cameron Diver for to take his closing words.
Thank you very much for those very kind words once again. Look, I'll be brief because I know I ran over time in my presentation. I'm very sorry if that stopped other people from asking questions. I've put my professional email in the chat for those of you who either have some questions or want to remain in contact. I'm at your disposal. I'd just like to say, as I think you've perhaps seen, this is a wonderful, wonderful subject. It's wonderful and scary at the same time, because if we don't advance through the law on issues of climate justice, we have some major societal challenges that we will have to address, even greater than the ones probably that we anticipate today. But it's wonderful because it brings together human well-being, environmental well-being. It brings science to bear. It brings issues of sustainable development from a Brundtland report perspective, and from a legal practitioner's perspective. It's a fascinating field, both of study and application, that can have a real and direct impact on helping to address the effects of climate change, and obviously helping the people who need it. And I think, you know, it's the global community really, but those who are most vulnerable reach a form of, if not the ultimate form, of climate justice. Incrementally, but not slowly incrementally, swiftly, I would hope. So I would just like to thank again KHAS University, the Climate Change and Law Laboratory, you, Aslihan, the Dean, Etche, Virginie, who I see there for the introduction once again, and everybody who's listened in to this. I'm delighted to have made a contribution. I'm proud as a practitioner to be able to contribute to thinking on this issue, and obviously to follow on in your series from 2 extremely distinguished speakers in your first 2 seminars. And I will follow with interest those that are coming up, and remain, as I've said, at your disposal for professional or personal contact on any of the issues and beyond that we've discussed today. So continue to fight the good fight. Climate justice is the defining issue of our time, at least in my view. And as a legal practitioner, and I know many of you are, we really do have a role to play. It's stimulating, it's exciting, it's international, multi-sectoral, transboundary, transnational. It's all of the stuff that should get the creative juices flowing to help us all contribute to what is a real global issue, each with their own expertise and with their own small stone that will contribute to the construction of the overall edifice. So thank you very much.
Thank you, Mr. Diver. It's our pleasure. Really, we have really enjoyed today and learned a lot from you. Thank you so much.
It's been my pleasure. Thank you.
Thank you, and bye-bye to all. Looking forward to see you in our next event. Bye-bye.
Goodbye. Thank you.
Thank you.